I said that the common law and the UCC both have this same foreseeability requirement. The CISG's foreseeability test has two aspects to it. It is subjective, meaning what did the party actually foresee, and objective, which is to say what would a party ought to have foreseen. And the test is not going to be based on the reasonable person standard, but on how foreseeable was the breach. So in this case, think of one of the pop-up stores that open for around the Halloween period. And we start to see those stores really starting from August 15th, running up through October 31, or maybe November 9th, to give them time for clearance sales. That's the only time that party store is going to be in business, that Halloween store. So if I own one of those businesses and I'm contracting for Halloween costumes, and the Halloween costumes are supposed to arrive on August 15th, but instead they don't arrive until October 15th, I'm going to suffer a loss of profit. And that loss of profit should have been foreseen by the party. There is a limited time in which a party can sell Halloween costumes. So when we talk about foreseeability, that's sort of the aspect we're looking at. Interest is a special type of consequential damage, meaning if you as a buyer breach and you fail to pay me the goods, when I sue you for the breach, I can sue for the purchase price, but I can also sue for the interest that I would have obtained on the sum had you provided me with the price. So interest is a special type of consequential damage, and unless the parties have waived it, the CISG gives the parties the right to claim interest on that amount. Liquidated damages are monetary damages that the parties have agreed to in advance. Oftentimes it can be difficult to calculate damages after the fact. What was the harm that was suffered as a result of the breach of the contract? Well, the parties are entitled to put those amounts into their contract and then be able to claim those amounts strictly through what the contract says. So they are liquidated damages that are set out by the parties in the contract. And this oftentimes occurs when it is difficult to calculate what the loss would be. Now, another aspect of liquid damages you should know is that the amount of liquidated damages should bear some relationship to the actual damages that were caused. So for instance, many of you live in apartments or you're subject to a lease. And those lease agreements will often contain a late payment fee, a separate fee required if you don't pay your rental amount by the 3rd or the 4th or the 5th of the month. That late fee is actually a form of liquidated damages, which is to say you failed to perform according to the terms of the lease agreement. We have set out what it is that we are entitled to receive as a result of your failure to perform. And similarly, those late fee amounts must bear some relationship to the actual harm caused by the failure to pay your rent on time. So if you rent a place for $750 a month, a late fee of $10,000 is out of proportion. So it's not going to be supported as the actual liquidated damages. And it applies the same situation, for instance, in where we have a sales contract, a contract for the sale of goods. Now, damages may be calculated, and again, this is set out in Article 74. I'm going to do a special video about how to calculate damages, but in essence, understand that the non-breaching party, the aggrieved party, is entitled to its expectation interest. And we are going to stack up those remedies, those monetary damages, to an amount that is going to be necessary to satisfy their contractual expectations, their expectation interest. Now, this loss, we can call it non-performance loss, direct loss, loss in value. And again, it's measured by the market value of the benefit which the aggrieved party has been deprived of because of the breach. The CISG says that compensation is measured by the difference between the value to the aggrieved party of the performance that should have been received and the value to that party of what, if anything, actually was received. And again, getting back to that same idea that we've talked about, difference between your expectation interest and what you actually received. CISG Article 77 contains a duty to mitigate. That mitigation duty we've already talked about requires the party, the aggrieved party, the non-breaching party, must take the measures that they are obligated to do to mitigate their loss, reduce their loss, including things like loss of profit. Now, if a party fails to mitigate, the party fails to buy substitute goods, or the party fails to resell the goods, the breaching party can claim a reduction in the damages by the amount that should have been mitigated. Meaning if the contract price for the good was $50 and the market price of the good was $70, if you as the buyer failed to purchase the substitute good, I, in measuring my damages, can measure those damages by the difference between the $70 market price and the $50 contract price, regardless of whether you took advantage of that $70 market price. The same way on a resale, if the buyer breaches and the seller goes out to resell the goods and the contract price is for $50 an item and the resale amount is $30 an item, the market price, the seller can sue for the difference between $50 and $30. If, however, the seller fails to resell the goods, does not undertake a good faith effort to resell the goods, then the measure of damages that the buyer is going to have to pay is going to be the difference between the contract price and the market price, what the seller should have sold the goods for. The seller can't simply lay back and attempt to receive the entire amount of damages. They must mitigate. And if a party fails to mitigate, the court or the arbitration panel can take into account what they would have received had they mitigated, and they can offset that against the award that is going to be made. Remember, when a person suffers damages from a breach of contract, they have a legal obligation to minimize the resulting loss. Mitigation for a buyer is cover, which is to say the purchase of substitute goods. Mitigation for a seller is resale of the goods to another buyer.